Welcome, everybody. Thank you so much for joining us today. This is our Immigration Update webinar. We are Changes Immigration. I'm Samar Shams. I'm the managing partner of Changes Immigration. Anna, would you like to introduce yourself?
Yeah, so my name is Anna Asumedu, and I am a trainee solicitor at Changes Immigration.
So we're really excited about this webinar today. We have a jam-packed session for you. This is being recorded, so just be mindful of that. If you have any questions, please put them in the chat, and we'll try to get to them. I'm having some technical difficulties this morning, so please bear with me. And if you hear knocks and bangs, I apologize for that in advance. We're having some emergency work done where I am today. So without further ado, I'll just quickly go through what we're going to talk about today. So first of all, we're going to talk about changes to sponsorship, and that is going to be a big focus of our session today, because I know it's of interest to a lot of our attendees. We will talk about the government fee increases, some changes to the EU settlement scheme and the youth mobility scheme, and then we're also going to talk about the electronic travel authorization scheme that was introduced just yesterday for the UK. All right, so here we go. Sponsorship changes. So we are going to reach quite far back to some earlier changes that I've noticed a lot of sponsors haven't clocked, just to make sure everybody's on the same page. So we will start with these changes that were introduced in April 2023. They have to do with increases to the general salary thresholds for sponsorship. So what we're looking at here in the red table are the new general salary thresholds for the skilled worker route. And you will see that there are all the different options for gaining points under the skilled worker route, and the relevant salary thresholds have gone up for each of those. So the default salary threshold is now 26,200, up from 25,600 before April of this year. The hourly salary threshold has gone up, so skilled workers need to be paid at least $10.75 an hour, and the senior or specialist worker and UK expansion worker general salary thresholds have gone up. Those are global business mobility visas, and the general salary threshold for those have gone up to 45,800. Okay, so here we have some examples of going rate increases. Okay, so as many of you will know, when you're sponsoring a non-UK national to work in the UK under the skilled worker route, you have to fulfill the general salary threshold, the hourly rate threshold, and also the going rate or percentage thereof, depending on the points option that you're using. And there have been changes to the going rates. They're not all increases, as you can see from the table here, although on average, the salary, the going rates have gone up. But you'll see for chief executives, it's gone down slightly. We've just listed here some of the most common SOC codes that we handle for sponsors. But of course, the list is hundreds of roles long. If you have questions about a specific role, please get in touch. Now, one thing to note, and this is one of those things that I think a lot of sponsors have perhaps missed, is that the going rate levels have changed. but also the basis, the hourly basis on which those going rates are determined has also changed. So previously, most roles, the going rates for most roles were based on a 39-hour week. And now they're based on a 37.5-hour week. And so if your worker is working more than 37.5 hours, per week, then you're going to have to prorate that salary to see if it meets the relevant going rate. So do be mindful of that. Now, I should stress that this is for CAUSE, certificates of sponsorship, that are assigned 12th of April 2023 or later. So if you have somebody who's in one of these roles and you sponsored them before then the new going rate thresholds and indeed all the new salary thresholds will apply, say if they apply for an extension, but you don't have to do anything about it in the meantime if you assign the CAUSE before 12th of April 2023. Anna, are you going to discuss the student switching restrictions for us?
Yes, Summer. Thank you. So with student switching restrictions on 17th July this year, the Home Office published some updates in the immigration rules. And these updates included restrictions for student visa holders who are looking to switch from their student visas to visas on the work route. And these restrictions were in effect immediately they were published. So the work routes include skilled worker permissions, global mobility permissions, global talent, government authorized exchange, and senior or specialist worker permissions. The restrictions also included student visa holders who are wanting to switch to become dependents of migrants on these work routes. Now, students cannot switch to work in these work routes until they have completed their course of study, the start date on their certificate of sponsorship, which is also known as the course, is not earlier than their course completion date. And then also if, let's say the students are studying towards a PhD course, their course start date must not be earlier than 2 years after the start date of their PhD course.
Yeah, so effectively, they'll have had to have done 2 years of a PhD. Is that right, Anna?
Yes, that's correct. Okay. So the documents that you can use to prove course completion include 1, a student's results transcripts. Number 2, official letter from the student's institution confirming the course end dates. And then number 3 is the student's confirmation of acceptance, also known as the CAS. This would be for PhD students. The CAS is basically a sponsorship document for students to use to apply for their permission. There have also been restrictions on students' dependents. From January 2024, only PhD students, research-based postgraduate students, or students studying other doctoral courses will be allowed to bring their dependents.
I'll just jump in to add that the instructions to caseworkers that's published by the Home Office when they're assessing these applications tells them to refer to a student's confirmation of acceptance for studies, or the CAS, when assessing the course completion date. So they should be looking at that anyway for all of the applications where a student is switching, but don't leave it to the home office. Definitely, submit the documentation of the course completion date to support the application. Should I move to
Yes.
the next slide, Anna?
Yes, please. Thank you. Okay, so there was an allowance for students to start their sponsored role earlier than the start date on their course. Usually, let's say you would have to wait for a permission, for your permission to be granted before you can start, let's say, your sponsored role. But when it comes to students, there was an allowance that allows students to start their sponsored role before the start date on their course. We can note that this allowance was not affected by the recent updates. So students are still permitted to start their sponsored role before the start date on their course.
Yeah, so this is an allowance. This is an example of a provision in the rules that it seems a lot of sponsors didn't know about. This was in place before the restrictions were introduced with immediate effect on students switching on 17th of July this year. And it wasn't immediately clear whether those new provisions conflicted with this pre-existing allowance for students to start upon submission of the online application. The Home Office has confirmed that this allowance remains in place. So
yes,
students fulfill these conditions can still start as soon as they submit their online application. I would say one thing to keep in mind is that if the application is refused, if the skilled worker permission application is refused, then you can't continue to employ the student, even though they were allowed to start when it was submitted. So just keep that in mind.
Yeah, and adding on to Summer's point, within 3 months of a student's course completion date, they can start full-time permanent role after submitting the valid visa application. And then the student can also start in their sponsored employment after their visa application is approved and before the start date on their course.
Okay, we have a question in the question and answer session, which is actually from another UK immigration lawyer. And it's, can a student dependent switch visa even if the main student applicant has not finished their studies? I think we're going to address that later. Isn't that right, Anna?
Yes, we will.
So we'll get to that later if that's okay, Dahlia. Thank you. Okay. Now, I wanted to talk about the home working reporting duty. So this is another change that was made earlier this year. The Home Office seems to have gone back and forth a little bit on it. They seem to be a bit non-committal. So they introduced a requirement in the sponsor guidance that you have to report if somebody is working from home. So if they're working from home on a permanent or a full-time basis, or if they have a hybrid working, and the way they've defined hybrid working in the guidance is remote work on a regular and planned basis. So we've interpreted that to mean, certain number of days a week. You've agreed with the sponsored worker that they'll be working from home. That would be regular and planned and would have to be reported. Now, it should be reported within 10 days of the arrangement occurring. I do think that there's a little bit of leeway. So if you have people who are working from home, you haven't reported it yet, don't be shy of reporting. It's always better to just go ahead and report something, even if you're late. And we did understand that the Home Office was going to retract this new provision. in talks with the Home Office, they intimated that they were going to do that, but they haven't done so yet. So do go ahead and report home working that falls under these criteria for any sponsored workers. And do share your questions if you have any. Right, let's talk about absences. So the general rule that's been in place for a long time is that a sponsor should terminate sponsorship if there's an absence without pay, or if there's reduced pay for more than 4 weeks in total over the course of the year. And that is in total. It's important to keep in mind. Now, there are a number of acceptable reasons, including maternity leave, paternity leave, that were always in place. Earlier this year, they added jury duty as an acceptable reason and attending court as a witness. So for all of those, they can be absent without pay. It won't count towards the 4-week in total limit per year of absences, after which you would have to terminate sponsorship. Now, they have changed the provisions about absences such that even if they have been absent without pay for more than 4 weeks in total, and the absence doesn't fall under any of the acceptable reasons, whether old or new, there's a new process by which the sponsor can still basically request permission to continue sponsoring the worker. So you have to report the absence, you report the reasons, the duration, any relevant effects on the salary, and then the UK Visas and Immigration will consider those reasons. They may or may not accept them. So it might still cancel the worker's permission, but they might allow the sponsor to continue sponsoring the worker. So that's new and interesting. I don't know if anybody's had experience of that yet. I see there's a question in the chat. Oh, hi, Maria. With absences, if we have another COVID-like furlough situation, what is the standing on that? So there were specific allowances in place for home working during COVID, during the pandemic, when such that you did not have to report changes in job location. Now, with the home working provisions now in the sponsor guidance, unless there is a specific policy that's brought in to address a situation like another global pandemic or a similar situation, if we have another COVID type situation, unless there is a special policy brought in to address that, then you would have to report the home working. Any changes to that. So if you have somebody who's working from home 2 days a week now, and COVID happens, and another lockdown happens, they're going to be working from home, then unless the Home Office says otherwise, we would have to report all of those. You'd hope that they would again make the concession to allow to allow sponsors not to have to report for every single sponsored worker, because everybody's going to be working at home, but they might not. So under the current provisions of the guidance, you would have to report that. I hope that answered your question. Let me know if not. All right, I'm going to move on to talk about dependents a bit. So they've changed the policies on dependents somewhat. So for partners, they're assessing documentation slightly differently. And there's new guidance for caseworkers where they will take a marriage certificate as evidence of a genuine relationship, but dependents will still have to evidence that their relationship is subsisting, including spouses. And so that means submitting documentation of cohabitation. and ideally also of shared financial commitments. Now, the way this has been implemented to date has not been consistent or correct, as far as we've seen. So the certain application forms are asking for irrelevant documentation from partners. So I think it's going to take some time to settle down into really understanding what the caseworkers are looking for. I think that it's going to take some time for the caseworkers to understand what they're looking for, because it's one of those situations where the rules are not very prescriptive, and so they cannot really refuse for lack of evidence. It just comes down to how the caseworker feels about your evidence. But we expect that in the coming months that this will settle down, and it will be more knowable. In the meantime, we're erring on the side of caution and just submitting more documentation rather than less to evidence relationships. Something similar with evidence for children. So there's a new appendix children. Now, the Home Office has said that it didn't intend to change policies by introducing the new appendix children. But we have noticed that when you get to the application, the end of an application form, for example, the application form will ask for things that it didn't ask for before. For example, a letter from the university of a 12-year-old child, or the bank statements of a 12-year-old child. So obviously that's not correct, and something we're hoping will be corrected in the coming months. Again, in the meantime, it should be sufficient to evidence the relationship and the parents' care for the children. Now, if the child is 16 years or over, then there is a requirement to evidence that they're not leading an independent life. We would anticipate that the government would assume that they're not leading an independent life for children younger than that. But again, the forms are asking for some strange documents in the meantime. So we are hoping that there will be more clarity on what's required in the coming weeks and months. I see that there's another question. Okay, Maria, I didn't answer your question properly. So Maria's asking if there's another COVID-like furlough situation and they're laid off and on furlough, so they're not working. Again, so during COVID, there was there were some special policies in place. If somebody is, I think there's a distinction to be drawn between being laid off and being on furlough, if I'm not mistaken. But if basically under the current provisions, if they're absent and they're not paid, or they're on reduced pay, for example, because they're on furlough for 4 weeks, then you would have to terminate sponsorship. So again, unless the government brings in special policies as they did during COVID, then that duty to terminate sponsorship would be effective. Oh, I'm glad I answered your question. I do hope that, we won't be in that situation again anytime soon, as I'm sure we all do. Right. I am going to go on to reporting start date changes. Now, actually, this change in policies was introduced a while ago, but nobody seems to know about it. So I am going to address it here. So the current requirement is that a sponsored worker must not start any later than 28 days after the latest of one of the following. So the start date on the certificate of sponsorship, and that's taking into account any sponsor note adjusting the start date, or the valid from date on their entry clearance vignette. So that's the little endorsement that's on a sticker in the passport, or the date of grant of permission. Okay, so because not everybody gets a vignette in their passport anymore, or if you're applying from within the UK, you're obviously not going to get a vignette in your passport. So you could also use the date of grant. So 28 days after the latest of one of those three circumstances is the latest that a sponsored worker can start. And if they don't start by the end of that period, then you have to report the new start date and the reasons for the delayed start, or you have to stop sponsoring the worker. And that report has to be done within 10 working days of the end of the 28-day period. Now, if you report the new start date and the reasons for the delayed start, it's again one of those situations where the Home Office will either accept your reasons, in which case you can continue to sponsor the worker, or they'll say, no, we don't accept your reasons, and then you would have to stop sponsoring the worker in that situation. So I'm just going to introduce a little poll to test knowledge. Make sure everybody retains the information. Right. So, dun, 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 get your votes in, everybody. Do you have to report a change to a start date if it's delayed by no more than 28 days? Ooh, neck and neck, yes and no? No's are winning. Get your votes in. Okay, looks like the votes are in. I'm going to share the results. Can everybody see that? There's 33% have said yes, you would have to report a change to a start date if it's delayed by no more than 28 days. And 67% have said no. So the no's are correct. And this is why I included this in the session, because 33% of people don't seem to know. They no longer have to report a change to a start date if it's not delayed by more than 28 days. Okay, from those three circumstances that I set out. Okay, now I want to ask you something else as well, if you don't mind. Do you have to report if a worker is absent on their first day? Do you have to report if a worker is absent on their first day? All right, we've got 50% yes. Oh, it's dropping. This is really interesting. I'm a big immigration dork, but I do think it's interesting. All right, get your votes in, people. Do you have to report if a worker is absent on their first day? They don't show up. You've sponsored somebody. They don't show up. Should you report that to the Home Office? What do you think? All right. Any other votes? Ooh, it's 50-50. I love it. Any other votes? All right, a few still coming in. I'll just wait a few seconds. All right, looks like the votes are in. I'm going to end the poll and share the results. Okay, so we've got 53% of people saying yes, you have to report if they're absent on their first day, and 47% have said no. In fact, you don't have to report absence on the first day anymore. So there you go. Okay. All right, there are changes. Changes have happened to the shortage occupation list, and there are some also further changes suggested by the Migration Advisory Committee. Now, it's important to keep in mind what the current benefits of being on the shortage occupation list are, which are only now a salary discount and a fee discount, visa application fee discount or permission application fee discount. So previously there were more benefits, such as not having to undertake the resident labor market test. But now that pretty much nobody has to undertake the resident labor market test, these are the only benefits of the shortage occupation list, a role being on the shortage occupation list. Some construction roles were added on the 7th of August. Now, the Migration Advisory Committee did suggest that several years ago, I think in 2019, if I'm not mistaken, and they've only just been added. And prison officers were also added recently. Now, the Migration Advisory Committee recommends that the Home Office remove roles or occupations from the shortage occupation list if the going rate is above the general salary threshold or on national pay scales. And that's because it doesn't serve any beneficial purpose to be reducing those salaries. And so the shortage occupation list doesn't help to address shortages in those roles. It just lets people have a lower salary, lets employers provide a lower salary. Okay. Let's talk about sponsorship processes and compliance. Now, the Independent Chief Inspector of Borders and Immigration a few years ago published a report recommending that the Home Office rely more on taking action against sponsors in their immigration enforcement efforts and less on raiding ethnic restaurants, basically, and applying civil penalties. And it seems that, you know, the Independent Chief Inspectors of Borders and Immigration's advice wasn't taken right away, probably because of COVID, but now it seems like it has been taken. We've seen a big uptick in enforcement action against sponsors. And there's also a lot more information gathering during sponsorship processes. So one change that's been introduced is a skilled worker genuineness requirement. So it's a requirement at the application stage now that the applicant must genuinely intend to and be capable of undertaking the role that's stated on their certificate of sponsorship, and they must not intend to take employment other than for the sponsored role that's set out on their certificate of sponsorship or as otherwise permitted by their conditions of stay, which means supplementary employment. That can be for up to 20 hours a week outside of the hours relating to the sponsored work, and either at the same level and in the same type of role or in a shortage occupation role. So that's what it means by otherwise permitted by conditions of stay. Now, the Home Office is now requesting information by email a lot more often when they're assessing applications, and they're interviewing sponsors and applicants. So be ready for that and don't panic. It seems to be happening quite a bit. Now, when caseworkers are gathering the information or conducting the interviews, they're going to be looking for information on how much the applicant knows about the role that's proposed for sponsorship and how much they know about the sponsor. They're going to be gathering information on the applicant's skills, qualifications, experience, and seeing whether they match the stated requirements for the role. And they're going to be asking about how the applicant was recruited. Some of you may know that now that the resident labor market test has been abolished for most sponsorship matters, if you have advertised the role, you have to provide evidence and information about that. But if you haven't advertised the role, then you still have to have on file somewhere an explanation of how you identified the individual that you're proposing for sponsorship. So they'll be collecting information from the sponsor on that and from the applicant and seeing if it matches up. Now, one trigger for requests for information and interviews would be if a sponsor is assigning an unusually large number of certificates of sponsorship for the same role, FYI. Now, one instance of the Home Office gathering more information during the application processes is when sponsors request undefined certificate of sponsorship allocations or apply for undefined certificate of sponsorship allocations. So the Home Office is now requesting details of the role, details of the worker, and details of any recruitment attempts when they're assessing applications for certificate of sponsorship allocations. So before you even submit an application, make sure you have all of that ready, ready for the Home Office would be our advice. Now, I'm just cantering through this because I'm conscious that we're a bit short on time now. There are a number of changes coming for the sponsorship management system. Now, those of you who have logged on recently to your sponsorship management system, to the sponsorship management system platform, you'll have noticed that there are a few requests that the Home Office has added recently in those messages that pop up when you first log in. So first of all, they want all key personnel's national insurance numbers to be added. So if you have a chance, do that. They also want every sponsor's company's house reference number to be added to the SMS, the sponsorship management system. And they've said that that's because it will facilitate the transfer of information about the sponsor to the new and improved sponsorship system, the new and improved sponsorship platform that people will be using. Now, for those of you in the audience where we have access to your sponsor licenses, we've gone ahead and updated your details to include your company's house reference number. So you don't need to worry about that. But for anybody where we don't have user access, we don't have level 1 user access to your sponsor license, I would suggest that you go in and put your company's house reference number, amend your sponsor license details to add that, because apparently it will help for a smooth transition to the new system. So a number of features are going to be rolled out in 2024. And here I'm just repeating what the Home Office has told us. One example is an example of a change is a single online dashboard. I'm not exactly sure what that means, to be honest, but there you have it. They're proposing a more streamlined end-to-end journey with improvements to accessibility and usability, and using automated checks with HMRC and Companies House so as to request less information. I understand as well that information that's entered into the certificate of sponsorship will be pre-populated on applicants' forms once the certificate of sponsorship is linked to the application form for permission. All right, let's talk about government fee and penalty increases. Over to you, Anna. Oh, you're on mute still.
Oh, sorry about that. Yeah, thank you, Summer, for running us through your section. So let's discuss the application and priority fee increases. There have been increasing the immigration fees since the 4th of October this year. And according to the government, this is in order to raise funds and raise funds wage for UK civil servants. Visas that have been affected include visit visas, skilled worker permissions, high potential individual, senior specialist worker permissions, global talents, indefinite leave to remain, and the student permissions. There's also been increase to the priority and super priority services. Okay, so some of the fees increases within the work routes include let's say the skilled worker entry clearance for 3 years or less was previously £625, but has been increased to £719. And as we can see from the table, the fee change is £94. With skilled worker leave to remain permissions of 3 years or less, the previous fee was £719, has been increased to £827. And as we can see from the table, the fee change is £108. Let's also look at the senior specialist worker up to 3 years, which was previously £625, has been increased to £719, and there's been fee change of £94. So we can all take note of this table and the various visa categories that have been affected by the fee increase. Let's go on to immigration health surcharge. So the Chief Secretary of Treasury stated that the increase to the IHS, which is the immigration health surcharge, was to ensure that it covers the full health care costs of those who pay it. It is not clear that this reason is justified. But then research reflects that migrants are generally healthier than the UK-born population and also access the health service less. So mainly people who are literally like mainly the working age are the ones who pay for these fees, but are less likely to access the service. Immigration health surcharge are set to increase later this year or early next year by 66%. And then the rate will increase from 624 to 1,035 pounds per adult per year. There's already a discounted rate for students, child or youth mobility scheme visa applicants, but these discounted rates are also set to increase from £470 to £776. There are also non-affected visas in this, and they include the visitor visas, health and care worker permissions, indefinite leave to enter or remain, and the EU settlement scheme permissions. These will not be affected by the immigration health surcharge increase. Okay, so let's talk about compliance in regarding these fee increases. Some of us may know that the immigration fees have been increasing over the years, and this is not the first time. So a common question could be, who pays these increased fees anyways? Would it be the sponsors or the migrant workers? But honestly, it is up to the employer or the sponsor to share the burden of these fees increases. But whilst you are considering that as a sponsor or an employer, you must note that there are restrictions to these. Restrictions include that the cost of immigration skills charge should never be shared onto a sponsored migrant. So sponsor must bear the cost of the immigration skills charge, and the immigration skills charge is a fee that is paid when a sponsor is assigning a cost to a migrant worker. Currently, the charge is £364 per year of migrant visa duration for small companies, and £1,000 per year for large companies. This fee must be paid a lump sum by the sponsor when they do assign during assigning of a course, and a sponsor is definitely prohibited from passing the fee onto the worker in any way. Also, any cost that is borne by the worker must not be linked to applicants or sponsored migrants' salary. So let's say other immigration costs such as the visa application fee or course fee can't be passed on to the migrant worker, but however, sponsors must ensure that any of these costs are not deducted from migrants' gross salary. The Home Office are very strict with this requirement, and we'd always want to ensure that the salary listed on the migrant workers' cost reflects their actual salary.
Yeah, I'll just jump in here to let people know that a number of sponsor licenses were revoked earlier this year, the beginning of this year. And a common reason the Home Office cited was what they call debt bondage, where basically they perceive that a sponsored worker is trapped in their job because if they were to leave, so much would be deducted from their salary that they can't afford to leave. And the Home Office did revoke a number of sponsor licenses at the beginning of the year for that reason.
Okay, so let's do some exciting activity here. This is a case study on student visa switch. So after this discussion, we can also address any question regarding the student visa switch. Okay, so David has received a job offer from Changes Immigration Limited and has been offered to be sponsored to switch his visa from a student visa to a skilled worker visa. David's course end date was 2nd of September 2023. However, David received his final results on 10th of September 2023 and found out that he needed to resit 2 modules. So the question is, can David apply for the skilled worker visa whilst waiting to resit his exam? Yes or no?
Get your questions in, get your answers in. The poll is open. Right, looks like most people so far are answering no.
At least like the no's are winning.
Like the no's are winning. All right, we're going to close the poll in a few seconds. If anybody else wants to get their answers in, please do. Yes or no? Okay, I'm going to end the poll. We'll share the results. So the no's have won, 73% no, 27% yes. What do you think of that, Anna?
Okay, I'm very sorry to disappoint the majority. So the answer is yes. Yes, because a student is allowed to switch their visa after the course end date. However, they do not have to have successfully completed their course.
Thank you.
Okay, Summer, would you like to address the?
I'm actually going to trot through because we've got 10 minutes and
Okay.
15 slides to go. So, right to work penalty increases. So it was announced a couple of months ago that from within the next few months, from early 2024, the penalties for illegal working, for employing somebody who doesn't have the right to work, who's not authorized to do the work that they're doing, is being they're being tripled. So currently, for first breach of the prevention of illegal working guidance, there is a penalty of £15,000. That is going up to £45,000 per instance of illegal working. And for repeat breaches, it's going up to £60,000 from 20,000. So you can imagine if there are several people who are working outside of their authorization, who don't have the authority to work in the role that they're doing, that can add up really quickly. You know, usually it isn't just one illegal worker when the penalties are imposed. It's usually several, and so these fees are going to add up very, very quickly and have severe effects on businesses. So do get your ducks in line in terms of your right to work checking processes. If you need any help, please reach out. It is going to be increasingly important. Another recommendation that the Independent Chief Inspector of Borders and Immigration made in that report on immigration enforcement was to widen the scope of the targeted businesses who are subjected to right to work penalties. So as I said, the focus was really on ethnic restaurants mostly previously, but we are already seeing that expand to lots of other sectors. So do make sure your right to work checking processes are ship-shape. All right, I'm going to quickly discuss the EU settlement scheme and the youth mobility scheme. There have been changes to each. Now, there have been a lot of changes actually to the EU settlement scheme. I'm not going to go over all of them. So for example, you know, there are changes about late applications, etc. What I'm focusing on here are the changes that will concern employers of people with permission under the EU settlement scheme. So one change that is going to be relevant for employers is that employees' pre-settled status is going to be automatically extended by 2 years before it's due to expire. And the Home Office apparently started doing this last month. Now, how do you know if your pre-settled status has been extended? It should be reflected in your digital status. So if you are an individual with pre-settled status, you can check your online profile. If you're an employer, you can ask for a share code again and check the right to work profile that's generated there and the end date that's reflected on that. They've also said that they're going to start switching people automatically from pre-settled status to settled status where they can verify the eligibility criteria through data sharing, through checks, mostly, as I understand it, with HMRC. That's what they're best set up for. They haven't started doing that yet. They've said they're going to do that from 2024, and they will publish more details in the coming months. Now, it's very important in order to benefit from these changes that the Home Office is able to reach you. So do make sure, and employers, you might want to send out a message to the relevant employees to make sure that your personal details are up to date on your account. And unfortunately, you can't see all of the information. So for example, you can't see your residential address, if I understand correctly. So if you're not sure if your personal information on your immigration account is up to date, you might submit an update to ensure that the information is correct. Just checking if there are any questions. There aren't any so far, but do let me know if you have questions. So that's it for EU settlement scheme. I'm going to talk about some changes to the youth mobility scheme. So just to give some basic information, it's a 2-year visa scheme for nationals from countries with which the UK has reciprocal programs, reciprocal agreements, to allow young people to come to the UK to experience life here for 2 years. It is a visa type that allows work. So many employers out there will have youth mobility scheme employees on the youth mobility scheme. So participating countries currently are Australia, Canada, Hong Kong, Iceland's been added, India, Japan, Monaco, New Zealand, Republic of Korea, San Marino, and Taiwan. Now, recent changes are that they've expanded the scheme for New Zealand citizens, and for they've expanded the scheme for New Zealand citizens so that they a wider tranche of age is allowed. So previously you had to be between 18 and 30. Now those up to 35 are allowed to apply, and their length of stay was increased from 2 to 3 years. And similarly, from 31st of January next year, Canadian and Australian citizens will benefit from the same changes. So they can apply if they're up to 35, and they will have up to 3 years of stay. Other nationals in the scheme, nationals of other countries in the scheme, will still be limited to 2 years. And they're still only eligible if they're between 18 and 30. Andorra is being added to the scheme. So I think the population of Andorra is about 80,000. I'm sure they're cheering heartily that Andorra has been added to the scheme with 100 places from 31st of January next year. All right, let's quickly talk about electronic travel authorization. I'm very sorry we're running a bit late today. So this scheme was introduced yesterday. Now, it opened yesterday for Qatari nationals only, who are planning to come to the UK, to arrive in the UK from next month. So what is it? It's a pre-travel authorization, okay? Now, the electronic travel authorization is permission to travel. It's not permission to enter. It's permission to travel, and it has to be applied for before travel. Now, why is the UK introducing this? Well, they said their motivation is security. So they want to know in advance who's coming to the UK, and they will then prevent the arrival of those that they perceive to present a threat. So who is this going to affect? It's going to affect what individuals who are referred to as non-visa nationals. So a non-visa national is somebody from a country that's on a list in the immigration rules, such that they do not need to apply for a visit visa before coming to the UK, all right? So they don't need they don't need to make any application. They just rock up at the border, and they may be granted permission to enter. So non-visa nationals are now going to have to complete this electronic travel authorization process before traveling, okay? And it's important to keep in mind that they will have the same permissions and restrictions as they currently do when they enter as visitors. So some business activities are permitted. So for example, negotiating deals and signing contracts, but paid work is generally prohibited, with only a few exceptions. I see some questions in the chat. I'm just going to pause to address those. Question around skilled worker visa fees. If the employer decides to help out with the cost of the visa application and the healthcare charge and want to deduct those money from the salary throughout a year or two, that is still allowed, correct? No, that's not correct. You shouldn't deduct contributions to visa-related fees from salary. If you'd like more particular advice on a specific set of circumstances, if you could get in touch by email, I'll provide my email at the end. That would be great. Somebody from Australia who's working on a youth mobility visa would be able to stay for 3 years. They do have to apply for an extension, so it's not automatically that they can stay for 3 years. You know, the expiry date on their current permission is still the expiry date, but they should be eligible for an extension for a 3rd year. Then we've got a question: if anyone's coming through youth mobility visa, can they bring dependents? They cannot have children, oddly. I think they can bring a partner, but not children, if I'm not mistaken. But if you don't mind, I'll follow up on that just to double check. Okay, so going back to the electronic travel authorization, one thing to keep in mind, and I think some audience members out there are working in the performing arts sectors. So there's an allowance for creative workers to come to the UK on the basis of a certificate of sponsorship and work in the UK in line with that certificate of sponsorship without applying for a visa if they're coming for up to 3 months. Now, they're going to need to apply for an electronic travel authorization before coming to the UK once it rolls out to their nationalities. And the electronic travel authorization requirement is also going to apply to transit visitors. So what is this rollout going to look like? It's not that everybody has to do this already. As I said, the scheme started yesterday, but just for Qatari nationals, and it's going to be rolled out over the course of 2024. So by the end of 2024, all visa nationals will have been added to this scheme, so including US nationals and EU nationals. So it's open. It opened yesterday for Qatari nationals traveling from next month. It's opening for nationals of Bahrain, Jordan, Kuwait, Oman, UAE, and Saudi Arabia, who are coming to the UK on or after 22nd of February next year. But it's eventually going to roll out to all non-visa nationals, including children. Irish nationals do not need an electronic travel authorization. What's the process going to look like? Well, you apply via the gov.uk website or using the electronic travel authorization app. You have to enter your email address, a digital photo, and pay £10. And then there's an application form that's going to ask for biographic data. It's going to capture passport details, contact details, and there are going to be suitability questions like criminality and history. Should take up to 3 days to process, so do ensure that any business visitors that are visiting your organizations or creative workers apply in good time. They won't be permitted to travel to the UK if the electronic travel authorization is not granted before they're due to board. So ETAs will be valid for 2 years from the date of grant, but if the passport that you use to apply for your ETA expires within those 2 years, then the ETA also expires. So it's important to keep that in mind. Don't get caught out by that. Don't let your business visitors get caught out by that. And just keep in mind, it doesn't guarantee admission. So people can still be denied entry at the border. It's just permission to travel. The Home Office is going to be using an automated process for approving electronic travel authorization applications, but all refusal decisions will be made by humans. And reasons for refusal would include if they're not able to verify the applicant's identity, if there is evidence of criminality, bad character, or bad conduct, previous breaches of immigration laws, previous breaches of visa conditions, or debt to the NHS. Now, a person who's refused an electronic travel authorization will need to apply for a visa. And there's no right of appeal or of administrative review for refusals. If you remember, refusals will all be made by humans. Now, if you make, if you, under UK legislation, if the government decides something on an automated basis and refuses it, then there should be a recourse to challenge that decision. But because all of the refusals will be made by humans, only approvals will be challengeable. So there you go. You can challenge approvals, which I'm sure people won't do. Okay, so I'm really sorry we ran over. I see a few more questions, which I'll try to address now. But if you need to go, of course, please do let us know by email. Contact either Anna or myself. Our details are here. So please feel free to do that. I'll just check out any further questions. I think that's it then. Okay. It doesn't seem. Oh, okay. So Marie has asked if we will share the slides. I will be sharing the slides with one caveat, which is that we won't be sharing the slides with other UK immigration providers who have attended today. We don't share the slides as a matter of course. We would share a recording as a matter of course. If you particularly want a copy of the slides, then please email me. Maria, I've noted that you want a copy of the slides, so that's fine. You don't need to email me. But if anybody else wants a copy of the slides, can you email me to request them? And we'll send them on. But otherwise, we'll just be distributing a recording. Okay. Well, thank you so much for making time to join us today. I really appreciate it. And if you have any questions, don't hesitate to let us know. Anna, do you want to say bye as well?
Yeah, sorry. Thank you so much to everyone. Yeah. Bye.
Bye. Thanks, everybody.